Hello, everyone, and welcome to Uncivil Law. For today's stream, we are responding to Stupid Article Time, a sometimes series on our channel where we respond to stupid articles written by the press about law because they don't understand law or refuse to understand law or whatever. So we are doing that today, and we take our attention to the New York Times, which has written a stupid article, and I apologize for the hard to read title because I'm using this through a service to get past their paywall, so I apologize. But this stupid article is called How History and Tradition Rulings Are Changing American Law. How exciting. And then it has the subtitle, A New Legal Standard is Gaining Traction Among Conservative Judges. The one that might turn back the clock on drag shows, gun restrictions, and more. Okay. So let's start with the basics because that's always helpful. If you want to interpret a law, any law, a regulation, a statute, a constitutional provision, there are a couple sort of master tools that we use to interpret this in sort of statutory construction or constitutional construction or whatever. There's a couple master tools we use. Now, I will go through these tools to help illustrate it to you. One of the tools is text. Just literally the words on the page. What do the words on the page say? Text is a great place to start. History is one of the tools we use, which has now gotten the more fancy phrase history and tradition, but I think that's the same thing. So we'll just call it history. History is literally how did we get here? What is the history behind this law? Because this law didn't exist, just come out of the ether. It is coming out of somewhere. So what is the history of the law? How did it come to be? What is the history? It will help us understand the law. Because if you understand what it was responsive to or understand what came before it, it probably helps us understand a little bit about what this thing is. So history is one of the tools we use. Another tool we use is intent. What is this law trying to do? What is its purpose or aim? Another tool we use is called precedent. That's something we use in the common law system. That's what common law is. Case built on case built on case. So the precedent is the case law history, if you like. What is the interpretation history? Not only prior to the thing being written, but of course subsequent to it, more importantly, because the precedent of interpretation, right? How's this thing have been interpreted in the past informs how we understand it now. That's common law. And then finally, we have policy. What is in the good of the order? What is in the good of the people? Okay? Now, the thing that separates conservative legal thinking from left-leaning legal thinking is the order of priority of these tools. That's basically the fundamental difference. So the conservative tends to put text first. That is their primary thing. And then they'll look to history and tradition. And they tend to disfavor intent and significantly disfavor policy because judges don't do policy. That's not what they're for. The conservative judges think that policy is best left to the policy branches, which is to say the president and Congress. That's what they're for. They're for policy. That's not what the court is for. So the conservative justices hate policy, and they're not much more a fan of intent. Because, well, rather than what the law's trying to do, we just try to figure out what it is. The left-leaning legal thinking kind of inverts this on its head, or at least rearranges it to significantly more favor policy and more favor intent. So rather than being disfavored or repugnant tools, the left-leaning legal thinking favors these tools or makes them dominant, depending on who's doing the ordering of the tools. So that is the thing. So first of all, I walk you through this to illustrate that this is not a new legal standard. This is not new. It is just one of the tools that has been in existence, and the only thing perhaps new is the degree to which it's being leaned on. The prioritization of it perhaps is new. It's been elevated in importance, perhaps, in the conservative legal thinking compared to the other tools. It's gained a new renewed priority compared to the other tools. But, nothing up my sleeves, nothing magic, nothing nothing to write home about. It's just what it is. And history and proper interpretation helps you understand what a statute is. So, for example, if you have the First Amendment and you have the freedom of speech, and I've talked about this before, the freedom of speech is a specific thing. It's the freedom of speech. The freedom of speech is not freedom of speech. It's the freedom of speech. The word the becomes very critical because the word the is a definite article as opposed to the word a. It is a definite article. It refers to a specific thing. So it's the difference, if you like, between saying a piece of land and the piece of land. A piece of land could just be anything. The piece of land is referring to some specific piece of land that hopefully has been previously established in our conversation so that it makes sense. But the piece of land is a specific thing. And in the same way that you can point to land somewhere and say this is land, it surely is, but whether it's part of the piece of land depends on the boundaries of the land, right? I mean, this is, again, nothing complicated. If you own a house and you own a yard, you have the entitlement to the piece of land. That's defined by your boundaries and not a different piece of land. So you're saying, for example, what about my right to this land over here? I'd be like, what about it? It's outside your boundaries. It's not part of the piece of land. Go away. So that's the proper way for me to think about the First Amendment as well. When you talk about the freedom of speech, it's not freedom of speech, it's the freedom of speech. What's the difference? Well, for example, defamation is not protected by the First Amendment. It never has been. For my money, it's just not within the boundaries of the freedom of speech. It never has been. So for my money, I don't even view it as an exception to the First Amendment. Although you could think about it that way, but I don't view it that way. I tend to view it as just not encompassed within the definition at all. It's just not part of the freedom of speech. Never has been, was never included. So that's an example, right? You might be able to say slanderous things. You might be able to speak them. You might be able to write them down, but you don't have any protection to them. So that's, kind of the same thing. And you can also interpret any other provision in the Constitution the same way, by the way. The freedom of speech was just an example. The right to keep and bear arms, obviously, another example. And this is where I think a lot of my more conservative brethren trip up a little bit because they say, well, I have an arm, therefore I have a right to it. And I'm like, that doesn't quite follow. That doesn't quite follow. In the same way that saying, well, I have land, therefore I have a right to it. That doesn't quite follow, right? To say I have an arm, whatever that arm is not necessarily to say it's within the right to keep and bear arms. Those are at least two different conceptual universes. They may significantly overlap, but they are not one and the same thing. So I think the conservatives, or some of my brethren on the right, trip up a bit because they're like, well, they'll say, for example, the Second Amendment says shall not be infringed. And I'm like, well, shall not be infringed is interesting and all, but what shall not be infringed? What shall not be infringed? The freedom of the right to keep and bear arms. So if it's not part of the right to keep and bear arms, then you can infringe it all you want because it's not part of the right. And now we have to have a discussion about what the right to keep and bear arms is and how we do that. Well, the tools I just told you about, right? The text, the history, the precedent, and so forth and so on. That's how you would go about doing it. And you can do it for any provision of the Constitution or any statute or any regulation or whatever, because the tools are the same. The tools are the same. So when they say that this legal standard is gaining traction among conservative judges, one might that turn back the clock. Yeah, I mean, yes, but that was the goal. That was the point. The entire point of the Constitution was to freeze certain fundamental rights for all of time. Now, we did give a mechanism to change them, but it requires extraordinary political will because we view them as so important. So in order to change it, you can do it. It just requires an unbelievably robust consensus because, well, we were concerned about the tyranny of the legislature. We were concerned about the tyranny of the politicians. And why might ever the Americans be concerned about such a thing? What in the foundation of our country would lead them to be concerned about the possible tyranny of a parliament? Whatever concerns could those be? I say with dripping sarcasm. So the entire point of the Constitution was to take certain choices away from Congress. That was the goal. Congress shall pass no law, etc., and so forth. That was the purpose. It was meant to freeze it in time. That was the goal. So they say it turns back the clock like it's a bad thing. But from the conservative point of view, it's not a bug. It's a feature. That's what it's supposed to do. That is the thing it's supposed to do. It is supposed to turn back the clock to 1791, when the amendments were ratified. That the freedom of speech, whatever it means, is frozen in time. The right to keep and bear arms, whatever it means, is frozen in time. The technology may change, but the right is the same. So as we get, for example, we get past, just the printing press, and we get to, radios and television and Facebook and the internet and YouTube, for example, right? Then the freedom of press is understood a little bit differently, but it's the technology that's changed, not the right. And so too with firearms. So I give you all this background so that you can be properly understanding of the stupid, so that you can properly understand the incredible stupid. They want to not roll back the clock. They find the Constitution inconvenient. They are annoyed the Constitution freezes certain things in time, even though that was the goal. That was literally the point. So that's what they're complaining about. And this person is apparently a fellow at Yale Law School. So they're a particularly well-informed idiot. So I will read this and comment on this as we go. In November of 2022, a group of LGBTQ students at West Texas A&M started planning a drag show for the following spring. They wanted to raise money for self-deletion prevention and stand up for queer self-expression at a time when conservatives in Texas, in the name of protecting children, were mobilizing to shut drag shows down. Okay, I mean, I will simply note as a general proposition that the regulation of content which appeals to a sexual interest has long been regulated and very tightly in the United States in time, place, and manner restrictions. So the degree to which drag shows can or cannot fall into that category, well, one might quibble, but to the extent it can be thought of as appealing to the prurient interest, as we say, then the state's ability to regulate it would come along for the ride, and that's, again, informed by precedent. The student group, Spectrum VT, set a few guidelines. The show would be PG-13, whatever that means to them. The students told the university, kids under the age of 18, the students had in mind the siblings of a performer, could come only if they were accompanied by a parent or guardian. Okay. Despite this plan, the president of West Texas A&M, Walter Wendler, announced March 2023 that he was barring the event from campus. In his statement on his personal website, Wendler called the drag show divisive, derisive, and demoralizing misogyny, which, I think there is some truth to that. Spectrum WT sued, arguing that the decision to cancel the show was a textbook example of discriminating against speech based on viewpoint. Well, no, not necessarily viewpoint, although maybe, but perhaps more about the conduct. So to the extent that this was going to be regulated based on what they were doing at the show and what exactly PG-13 means, then, maybe, but maybe not. So there are some questions to be had, but, okay. Legally speaking, Spectrum W2 has a strong case. I mean, on first blush, I would tend to agree. If we're dealing with adults, which apparently we are, and we're at a public university, which it seems that we are, then the First Amendment would apply, and they should be allowed to have their show. If it's based on people who want to attend, seems probably okay to me. I mean, that's, I'd obviously need to know more. Somehow I think the New York Times might be deceiving me somewhat about this story. Somehow they may not be presenting the most accurate story. Why ever would I be concerned about that? So if they're telling the story correctly, then I would tend to agree, but I'm doubtful. So I'd want to know more things. Since the 1970s, the Supreme Court has ruled the First Amendment protects speech on public university campuses, no matter how offensive, and despite conventions of decency, as two decisions put it. Fair enough, and I tend to agree with that proposition. Universities are for adults. They do adult things, and unless it is legally obscene, which is a whole nother level, then, it should be fine. So that sounds okay. Wendler acknowledged that he was refusing to do the drag show to take place even where the law of the land appeared to require it. Okay, so he's disobeying the law, so go fuck him. All right. But the lawsuit landed on the docket of Judge Matthew J. KMark, a Trump appointee to the federal bench in Armelo, who is the author of several sweeping arch-conservative rulings. We might have to pull this ruling, I think, by the time we're done. We might have to pull this ruling to see what we think. And in the drag show case, Judge KMark had a new tool supplied by the Supreme Court. Known as history and tradition test, the legal standard has been recently adopted by the court's conservative majority to allow judges to set aside modern developments in the law to restore the precedents of a distant past, or more to the point, keep the First Amendment in its proper lane. That is the thing. Keep the First Amendment in its proper lane. The First Amendment protects what the First Amendment protects, and tautologies are tautologies. But we need to figure out what the First Amendment protects. And maybe this is it, maybe not. I don't know. Somehow I think I'm being deceived. The conservative justices applied history and tradition test in 3 major rulings. Hey, Tony, could you do me a favor and find the district court that this thing is, the district court decision that this thing is alluding to? Could you find a link for it, please, so I don't have to go pulling it at the end of the stream and we can go discuss it? That'll be fun. Anyways, the conservative justices applied the history and tradition test in 3 major rulings decided in the space of a week. In June 2022, first, they struck down a New York restriction on gun ownership for being out of line with the nation's historical tradition around regulating guns. Yeah, the Second Amendment means something. The right to keep and bear arms is the right to keep and bear arms. So how do we understand what the right is? Well, history and tradition is a pretty good place to start, it seems to me. So yeah, that seems correct. Next, in Dobbs v. Jackson, the conservative majority ended the constitutional right to abortion in Roe v. Wade, which was a horrible decision on pure legal levels. It didn't make any legal sense at all, as has been widely critiqued by any number of people. It was a disaster of a case, legally, because it was not deeply rooted in the nation's history and tradition, which it's not. Yeah, it was illegal in pretty much every state, right up until Roe versus Wade. Yeah. Finally, the court held that a public high school's decision to let go of a football coach for praying with a crowd he gathered at midfield was out of line with historical practices and understanding of religious freedom. Again, some vital context that is absent here. It was out after the game, and there was some other context elements that were relevant to that decision. It wasn't just the coach was gathering people for prayer. It was after the game, and it was only the people who wanted to attend, and so forth and so on. So, there's that. The flurry of history and tradition opinions prompted an uproar among the more liberal conservative watchers. What counted as historical tradition? Well, you know the answer to that as well as I do. You go to you try to figure out from whatever resources you can dig up to find how these things were understood in the past. And we do have 1,000 years of common law, so it's not like we're dealing with nothing here. The open-ended nature of the term seems to invite a freewheeling survey of the 18th and 19th century. Yes, that's essentially correct. We're dealing with something in 1791 when we're talking about the Constitution. And as the Supreme Court has pointed out, and is probably true, all else being equal, things that happened closer to that date, both before and after, are probably more informative than things that happened later, after or before that date, further away from that date. Because, things that were happening at the same time are probably more informative of the thinking. It isn't necessarily dispositive, but yes, it is a clue. So more things that are happening closer are probably more relevant, all things being equal, because you're trying to understand what something meant in 1791. That's what you're trying to do, right? So you're trying to understand, what did this thing they wrote in 1791 mean? So the closer you are to that date on either side of the date, yeah, it probably helps to understand a little bit more. Makes sense. It's basically a fancy way of saying, if the men in power didn't recognize this right as a fundamental in ye old times, we don't recognize it now. Correct. Correct. That is, you are 100% correct. The Constitution establishes certain fundamental rights. It does not establish other things which could be fundamental rights, I suppose. But if you want a new fundamental right, amend the Constitution. That's what it's for. And if you can get a robust enough consensus, then, go nuts. The court was playing memory games, in the words of a widely cited law review about Dobbs by Reva Siegel, a Yale law professor. Why did the conservative majority appeal to history tradition in exactly those cases in which it's changing the law? Well, because if we're going to change the law, then it'd probably be helpful to get it right. So going to history and tradition to understand what it meant at the beginning, to go back to ground, makes sense, right? So yeah, so you do have a bit of attention, I suppose, and the conservatives don't really have a great answer for this, and I'll admit to as much. The conservatives really don't have a great answer for when should you overrule precedent. We don't really have a great answer to that question. We don't really have a systemic answer that can be applied in, it seems to me, a robustly consistent way. So we're not quite sure when you're supposed to and when you're not supposed to. But we do value the steadiness of law, because conservatives by their nature are conservative. And one of the things that defines conservative and conservative thinking is, how much risk tolerance you're willing to have, or how much change you're willing to tolerate, or how fast. So, yeah, that's kind of in the nature of the thing. All right, let's press on. Some judges express practical concerns as well. In one of many recent suits involving challenges to state and federal gun restrictions, Judge Carlton Reeves, an Obama nominee to the federal bench in Mississippi, pointed out that judges are not trained to sort through competing interpretations of histories. We're not experts in what white, wealthy, and male property owners thought about firearm regulations in 1791. Well, that's exposing a lot of bias, I think, isn't it? Yeah, but you could try. You could try. And there's a lot of ways to figure that out. And, by having, experts present evidence and so forth and so on. But you could try. Judges are not experts in lots of things. That's when the judges go get help from people who do know those things, and then they make a legal judgment. Conservatives, meanwhile, have their own furious debates. For them, a central question was whether the Supreme Court's conservative majority was deviating from originalism, the method of interpreting the Constitution championed since the 1980s by heroes of the right, like former Justice Antonin Scalia. All right, for my money, originalism is a label for the balance of the principles that I talked about at the start of the stream. So originalism is a label for how those things are listed in priority. Text, history, those are like dominant tools. Policy, intent, not so important. And precedent is sort of a bit of wild card. So those are sort of the ranking of things. All right. So if you lean more on history or lean more on anything, then arguably you're deviating from originalism. And that's why, to my mind at least, textualism and originalism are not the same thing. I think it's fair to say that textualism is probably the dominant tool in originalism, but textualism leans on it even more. So it leans on it even heavier as a weighting. It makes it essentially the only tool. If, maybe that's a bit extreme, but that's what textualism is. And Gorsuch is much more in the textualist stripe, which appeals to me. I think it makes a lot of sense. And so the judges who are looking at history, perhaps they are rebalancing things, potentially taking away from text, potentially taking away from other things, and revivifying history. So it's probably different than originalism, or it's a different weighing of things, but, it's still within the conservative legal thinking, at least in my mind. Originalism resembles the history and tradition test in focusing on the past, but its main selling point was to fix the meaning of the Constitution to the moment when it's written, to prevent judges from sustaining their values for wisdom of the nation's founders. Which is, if that's how you define originalism, then the textualists and historians are still originalists too. They're perhaps going about it slightly differently. They're using slightly different tools with slightly different ideas about things, but they're all trying to go to what did this thing mean when it was written, and not substituting our judgment for what they wrote, /meant, /whatever. So, yeah. Though originalism in practice has never lived up to the promise, because judges use it inconsistently or reach results they preferred, and I don't really think that's fair. The problem, as I mentioned earlier, is the right-wing legal thinking doesn't really have a great answer for what to do about precedent. We don't really have a great answer for how to deal with this problem. So when do we overrule it and when don't we? And it becomes a bit of a litmus test, or a bit of a subjective test. It's unsatisfying, right? So I suppose the one principled answer you could give to solve the problem, a principled answer you could give is, well, just ignore all precedent. And while that is a principled answer, I'm not sure it's necessarily satisfying, nor is it like really keeping with the fundamental legal tradition, which the Constitution itself, for that matter, is based on, which is common law. So ignoring precedent means you're giving up common law, because that's what common law is. Common law is precedent. That's what common law is. Civil law, like the French, don't really have precedent. The cases that came before in the civil law system are informative. They're persuasive, maybe, but they're never binding. That's the big difference between civil law and common law. In civil law, precedent doesn't really exist. In common law, it does. So, giving up all precedent is like giving up civil law or giving up common law. And that's, probably not ideal. So if you're like, okay, we probably shouldn't do that. We probably should not give up all precedent. And then the question is, okay, so when do you overrule precedent? When do you overrule it? When the precedent is really, really wrong? How do you determine that? We don't really have a great answer to that question. But of course, it's no better for the progressives or the left, except maybe they say throw out all precedent because we just want to do whatever we want to do, which, because we're just so rooted in policy. If they push policy higher up the tree, then precedent, if policy beats precedent right in the tree, then policy wins and precedent doesn't. So policy will win, and they ignore precedent whenever it favors them. So both sides of the legal aisle have a problem on a fundamental level. So we acknowledge our problem, but so yeah. History and tradition, unlatched from any one moment, is even more pliable and indeterminate. Well, I don't know about that. I mean, again, you're trying to understand what this thing you wrote in 1791 means, and that's going to be informed by a whole shit ton of things that happened before, and to some degree happened after, and understanding what it means. When you talk about the freedom of speech. So it is a bit more complicated, but I don't necessarily agree that it's pliable or indeterminate. It lets judges choose from a variety of sources, which makes it easy to cherry pick. Well, perhaps, but then it's just that they're not doing it very well, so do it better. Skeptics of history and tradition standard received some validation from an unlikely source. At a talk in Catholic University Law School in September 2023, Justice Amy Coney Barrett, a former Scalia clerk who joined Alito's opinion in Dobbs, used an old saying to warn that judges' hunt for historical sources could be like looking over a crowd and picking out your friends. Perhaps, but that just means we got to do it better, I hope, because I'm not sure what the alternative is. I guess ignore history, but I'm not sure where that leads you with. The same day, Judge KMark issued his opinion. And does this give me a hyperlink? I think it does. Let me just double check this real fast because I want to make sure if this is the thing for the case I need. Yes, it is. Sweet. So I've got the opinion for later, so we can review that. That'll be fun. Citing the Supreme Court approach to history in the 2022 case, Kazamensk says the early history of the First Amendment is drastically different than the modern version. The judge cited an 18th century treatise describing the government's power to censure licentiousness and 19th century ban on mailing on banning lascivious material. Damn it. Anyway, older rules like these continue to set up an outer limit on sexualized expressive conduct, the judge wrote. He wrote the university could bar the drag show an extraordinary and anti-modern result. Okay, perhaps. In March, the Supreme Court rejected the student group's request to hold a second annual drag show on campus. The judge's decision is now pending at the U.S. Court of Appeals for the Fifth Circuit. Also unresolved is a larger question. How much will the scope of American liberty change as conservative judges impose the past on the present? Again, it's the Constitution that imposes the past on the present. That's what's supposed to do. Lascivious. That's right. Lascivious. Okay. Lascivious. Thank you. Yeah, lascivious. You got it. Thanks. Judge Samuel Alito, the author of the majority opinion in Dobbs, has called himself a practical originalist, a phrase that fits his record of putting results above theory. In Dobbs, he used the history and tradition test to solve a problem that originalism posed for abortion opponents. When the Constitution was written and long afterwards, courts in the United States followed English common law. We still do. A set of rules and precedent developed by judges that widely permitted abortion in early pregnancy. Okay. Fair. I don't know if that's true. I don't remember that part of the discussion, but all right. 4 centuries before pregnancy tests, many people believed that fetal life began with quickening, when women felt the first fetal movement, usually between 15 and 18 weeks. Early American law didn't even recognize abortion as having occurred before that stage, according to a friend of the court brief. In 1973, when the Supreme Court decided Roe, Justice Harry Blackmun, in his majority opinion, contrasted this early history with a more recent state restriction. At the time of the adoption of our Constitution and throughout the majority of the 19th century, abortion was viewed with less disfavor, Blackmun wrote. A woman enjoyed a substantially broader right to terminate a pregnancy than she does in most states today. And, you know, Blackmun is definitely someone you got to consider because he's one of the OGs for sure. He's one of the great ones. Blackmun, who is not an originalist, did not feel bound by the distant past. He treated Roe as a resource, not a command. As Jack Balkin, a Yale law professor, has written in his new book, Memory and Authority, describing how lawyers often use historical facts. This approach to the past, as relevant but not determinative, was the majority form of constitutional interpretation, said Robert Post, author of the recent book, The Taft Court. I mean, I would agree with him that that approach was certainly much more dominant before the current court. Yeah, the left wing had a hold on the court, and history was down in the priority list. Intent and purpose were elevated, and history was denigrated. That was sort of, yes, that was a fair way of describing the court at that time. History was never a simple fact to be ascertained. It was always an interpretation of the meaning of widespread practices. Well, maybe. The cornerstone of Blackmun laid for the constitutional right to abortion came before the 14th Amendment, which Congress ratified in 1868 during Reconstruction. As one clause of the amendment states, nor shall any state deprive any person of life, liberty, or property without due process of law. Interpreting those words a century later, the court said the 14th Amendment concept of liberty in the due process clause included a right to privacy, which doesn't make any sense because once you actually try to impose a right to privacy, it doesn't really work. Right? It was a right to privacy insofar as it protected abortion, not a broader right, as you can see through any number of cases. In Roe, Blackmun said the right to privacy was broad enough to encompass a woman's decision whether or not to terminate her pregnancy. But it's not, though. It's not. As a protected liberty interest, that's really what they had in mind when they wrote that? I don't know, man. Since then, the majorities made up of liberals and conservatives have turned to the due process clause as the basis for adapting the Constitution to modern constitutional contentions, recognizing new rights, including parental authority and sexual liberties. Well, I would, again, chastise the characterization. The Ninth Amendment says that there are rights other than the ones we mentioned, and these rights may be more recognized in modern times, but when you talk about parental authority, I mean, that's not a modern thing. So the Constitution may not spell that out, but the ability of parents to mind their children goes back kind of as long as, parents have been having children. It's kind of in the nature of how that works in multiple different species. So, yeah. Anthony Kennedy, a Reagan nominee, took the lead. The generations that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom in all of its dimensions. Kennedy wrote in the landmark 2015 opinion, providing for the right to same-sex marriage. I did not like the way Kennedy wrote that opinion. I did not like his writing of the opinion. I just didn't think that it was rooted in a proper legal thinking. All right. And so they entrusted to future generations a charter protecting the right to all persons to enjoy liberty as we learn its meaning. See, that's a mistake. No, it was fixing in time liberty as that's understood as a more fundamental concept. It's not an open wheeling world to mean whatever you want it to mean. In Dobbs, however, Alito called the court's resilience on due process clause in the case controversial. It was. Even Justice Ginsburg did not think it should be rooted in the due process clause. He stopped short of declaring it invalid, which would jettison too many modern rights and freedoms, like sweeping all the pieces off the chessboard. Only Justice Clarence Thomas, in an opinion no one else joined, called for such a reconsideration. Alito aimed to topple the right to abortion, and only that right. Using the history and tradition test, he purported to show that legal abortion was not deeply rooted in the nation's history, claiming that an unbroken tradition of prohibiting abortion on pain of criminal punishment persisted from the earliest days of common law until 1973. But Alito didn't acknowledge that in rare cases in which someone was convicted of causing abortion up to the Civil War, it was always after quickening. I did think that this part of the opinion was weak in the case. I did think this part of the opinion was weak, dealing with the history of common law as it relates to quickening and not. I criticized it at the time. I thought the opinion was weak and problematic. And such abortion providers came to public notice not because of their practice per se, but the pregnant woman had suffered badly or died as a result, said a professor of history at Harvard. Alito also made clear this claim. By 1868, the year in which the 14th Amendment was ratified, 3/4 of the states, 28 out of 37, had enacted statutes making abortion a crime even if it was performed before quickening. But according to Aaron Tang, a law professor at the University of California, Davis, that number is inflated. Substantial evidence suggests that as many of 12 of the 28 states continue to permit aborts before quickening, he wrote. Okay. Alito then pointed out more abortion restrictions through 1910, ignoring other moments in history, including steps some states took before and after Roe to ensure abortion would be legal within their borders under certain circumstances. Yes, I mean, there were some efforts by some of the legislature to expand abortion rights, which would have been perfectly fine, by the way, because the Constitution doesn't forbid it. So you can amend it if you want, and by legislation would have been fine. And that's the debate we're now having, whether or not we believe in that or not on the state-by-state level. He also relied on a 1997 case in which the courts refused to extend its concept of liberty based on the Due Process Clause to include physician-assisted self-deletion because it has no place in our nation's traditions. It was hard not to think that Alito was, as Justice Barrett put it, looking out over a crowd for his friends. Nice alliteration, nice literary tool, but not really intellectually honest. The history and tradition test could have even more far-reaching effects on other areas of law. Last year, for example, the U.S. Court of Appeals for the Sixth Circuit considered a challenge to Tennessee's ban on gender-related medical treatments for minors, brought by parents who argued that they had a 14th Amendment right to make decisions about treatments on their parents' children's behalf. Or more even properly, perhaps that children don't have a right to make it for themselves because they haven't reached the age of majority. In a majority opinion of a 3-judge panel, Judge Jeffrey Sutton agreed that parents have the right to make decisions concerning the care, custody, and control of their children, but ruled against the parents because they hadn't shown that the right to new medical treatments was rooted in the nation's history and tradition. A month later, another federal appeals court similarly upheld an Alabama ban on gender-related cares for minors. So, yes, parents have the ability to take care of their children and make decisions for their children. But the practice of medicine is regulated by the state. And obviously, parents can't choose anything that they might want to do for their children just because they can find a willing doctor. That doesn't make any sense, right? I mean, we need to figure out what lawful doctoring looks like. And so the question isn't, do the parents have the right to make the children for their children on behalf? Do the parents have the right to make the decision? That isn't really the question. The question is, does the state have the right to ban it as a medical practice? Because the state says it's not valid medicine. And if you go to the Constitution, then the answer is yes, because, well, it's not entrusted to the federal government, therefore it must be entrusted to the states, because that's how that works. So that would be essentially correct. Applied literally, the history and tradition test turns on whether a new practice is like an old one. If not, the courts can discount whatever modern goal it's supposed to serve. That's probably correct. That seems like a fair way of looking at what this thing is. But some of the justices are already wrestling with whether they've painted themselves into a corner. Dilemma was evident at the oral argument in November for United States versus Rimini, a case about intersetting damages of gun and violence, domestic violence. In 2021, Zachary Rimini was arrested for having a gun, which put him in violation of a 1994 federal law that made it a crime for someone to possess a firearm if subject to a protective order for threatening a spouse or partner. The rationale for the law, which many states have versions of, which by itself might be perfectly legal, right? Whether states can ban it and whether the federal government can ban it are, after all, two entirely different things. They're two different authorities. The federal government only has as much power as the Constitution gives them. The states have all reserve power. So it's quite possible that it's legal on a state level and not federal level. But, that's that. In any ways, the rationale for the law, which many states have versions of, is that a woman who lives with abuser are far more likely to be murdered if their partner has access to a gun. A Texas judge granted Rimini's ex-girlfriend a protective order in 2020 after she said Rimini threw her to the ground, dragged her to his car, and slammed her head against the dashboard. Months later, Rimini went on a shooting spree, which included firing at another driver after a car accident, prompting police to search his home and find his guns. But using the history and tradition test, the U.S. Court of Appeals for the Fifth Circuit reversed Rimini's conviction for illegal gun possession. The conservative appeal court struck down the 1994 law for being a historical outlier that our ancestors would never have accepted and thus invalidated under the Second Amendment. The past governed the precedent, which is true enough in the view of the Fifth Circuit. At the Supreme Court, the Biden administration was forced to defend the 1994 law according to the terms of history and tradition, which, yeah. The government argued that the statute fit into general tradition throughout American history of disarming people who were considered dangerous. But for much of American history, women who could not vote had little recourse when their family members harmed them. And the groups the government disarmed had nothing in common with domestic violence offenders. But the Second Amendment, though, means something. And I don't know whether or not you can disarm those people or not, but that would be within the meaning of the Second Amendment. So there's that. They included enslaved people and Native Americans. The Biden administration disavowed these examples, calling them odious because they were based on race. That left historical examples that were also not analogous, like British loyalists and Confederate rebels. Some conservative justices seem to search for a way to allow the government to disarm domestic violence offenders. The legislature can make judgment to disarm people consistently with the Second Amendment based on dangerousness, Justice Barrett suggested. Now it seems like as if the history and tradition tests were flexible and not really a command at all. Well, I don't know about that because maybe it's consistent with the history. I'd have to go double check on that, to be honest. Justice Brown Jackson, a liberal, used the argument to reflect on inconsistency. If we're still applying modern sensibilities, I don't really understand the historical framing, Jackson said. She was exposing the trap the Supreme Court set for itself and the lower courts. Either the past, however archaic, retains real command over the present, or the history and tradition is no test at all. Thank you, Recovery Addict, for coming over, and all your viewers for coming over. We were just discussing some of this stuff dealing with the stupid article time as it relates to this New York Times article, which does not understand history and tradition from a legal framework. And we are excited that you are here and joining us. So this article pointed to a decision by a judge that came down relating to whether or not drag shows could be properly banned by the University of West Texas A&M. So they think that this court got it wrong. So to analyze that question, we're going to go read it because that sounds like a good thing to do. So we are going to go ahead and do that and try to figure out whether or not the court got it right or whether or not they got it wrong. I am skeptical of the court's ruling, but I'm willing to be entertained or willing to be persuaded. So we'll see how it goes. All right, so let's read a little bit about this. Plaintiffs are a recognized student organization called Spectrum WT at West Texas A&M University and two of Spectrum's WT's officers. Plaintiff Spectrum WT strives to provide a safe space for LGBT students and allies to come together to raise awareness of the LGBT community and promote support and acceptance on campus and in the surrounding community. In furtherance of the mission, Spectrum WT holds events such as Lavender Prom, Queer History Night, and Queer Movie Night. Plaintiffs also planned a March 2023 fundraiser at WT Campus Event Hall to raise funds for LGBT self-deletion prevention. In papers filed with the court, plaintiffs described their proposed event as a drag show open to children accompanied by a parent or guardian. Thank you, DSN, for the 5 gift memberships. They are extensively appreciated. We appreciate everyone who helps to support this channel financially. It is extensively appreciated. The proposed event was tentatively scheduled for April 1st and branded a Fool's Drag Race. Cute. Due to a scheduling conflict, Spectrum WT agreed to hold the show one day earlier. But before WT confirmed the event, defendant Walter Wendler, the president of the university, stated his opposition in a letter dated March 21st, stating, quote, WT will not host a drag show on campus. In the letter, President Wendler analogized to another type of theatrical performance, blackface ministerials, to explain his opposition to any event exaggerating, stereotype, mocking, or objectifying a person based on appearance, bias, or predisposition. I don't think this analogy works very well, by the way, because although blackface may be very distasteful, the government can't ban it. And the university is a public university, which means they're the government. So they can't ban the blackface. People can be really upset about the blackface. They can protest the blackface, but the government can't stop the blackface. So this analogy is stupid. because they can't ban the blackface either, because that would be really dumb. Anyways, continuing on with apparently what he wrote. As a performance exaggerating aspects of womanhood, sexuality, femininity, and gender, drag show stereotypes women in a cartoon-like extreme for the amusements of others and discriminate against womanhood. Perhaps it does, but that's speech, boy. Any event which diminishes an individual or group through such representation is wrong. Should I rest misogynistic betrayal portraying objects as women? Yes, you really should. You really should, from a free speech perspective. If people want to get out there and with their speech say things that seem to suggest or outright say that women are objects, they're allowed to say those things. The First Amendment protects disfavored speech. That's kind of the point. Drag shows are derisive, divisive, and demoralizing misogyny, no matter the stated intent. Such conduct runs counter to the purpose of WT. A group or person should not attempt to elevate itself or cause by mocking another person or group. As a university president, I would not support blackface performances on our campus, even if told the performance is a form of free speech or intended as humor. Well, that's... You can't do that. It is wrong. You are wrong. I do not support any show, performance, or artistic expression which denigrates others, in this case women, for any reason. Mocking or objectifying in any way members of any group based on appearance, bias, or predisposition is unacceptable. No one should claim a right to contribute to women's suffering via a slapstick sideshow that erodes the worth of women. When humor becomes harassment, it's gone too far. That's just dumb. That's just dumb. That's just dumb legally. I cannot get behind any of this legally. Right? If there were going to be minors present, we could have a different discussion. But this apparently was going to be restricted to anyone, only people over the 18 or people who had a guardian with them. Which, you know, and even if the university wanted to go so far as to saying, no minors permitted at all, even assuming they could go that far, which I'm not sure they could do that, but even assuming they could go that far, they can't stop the adults from having the meeting, from having the presentation. If you want to have your blackface performance and the government is stopping you, that's a legal problem. The government isn't allowed to do that. You're allowed to get out there and say you're stupid. And then I'm allowed to say that you're an idiot. And the First Amendment is validated by us all. That would be great. President Wendler averred, which is to say offered, that harassment was inconsistent with WT's vision statement, the Texas Education Code, and federal workplace rules enforced by the U.S. Equal Opportunity Commission. No, but thank you for playing. Throughout the letter, President Wendler expressed support for the underlying mission and message of the proposed event, that is, preventing the self-deletion in the LGBT community by raising money for the Trevor Project. In closing, President Wendler offered a simple recommendation: skip the show and send the dough. President then filed and withdrew a motion for a temporary restraining order after electing to host the event off campus. But plaintiffs still seek injunctive and declaratory relief in addition to damages under 42 U.S.C. 1983 because their future events are allegedly in imminent peril due to the president's edict. These include Queer Movie Night, Queer History Night, and a second drag show tentatively scheduled for March 2024. Okay. Let's do some legal analysis. Free speech jurisprudence only intermittently invokes the historical analysis applied to other amendments and clauses. Said historical analysis reveals a free speech ecosystem drastically different from expressive conduct absolutives of the plaintiff's briefing. The founders focused on prior restraint of publication, specifically political pamphlets. I certainly will agree that political speech is necessarily at the top of the free speech pyramid, but that doesn't imply that other speech is not protected. Draft free speech clauses focused on protecting the right to speak or write or publish their sentiments, which is arguably exactly what this group is trying to do. Blackstone treatises extol freedom of thought and recognize police power, which is just the general power to do stuff, which states have, to censure licentiousness. The Comstock Act of 1873 permitted the mailing of obscene, lewd, or lascivious materials, which is currently being used right now to try to ban the abortion pill as we speak, at least so far as it goes in the mail. And Joseph Story's commentaries defined the free speech clause as protecting the right to speak, write, and print opinions upon any subject whatsoever without any prior restraint, which, yes, that's basically correct, but not the right to injure any other person in his rights, person, property, or reputation, which is the basis of defamation law, or to disturb the public peace, which, you know, fair enough, but none of those things. As written, ratified, and adjudicated for 150 years, the free speech clause harmonized disparate and competing interests using text, history, and tradition as guideposts, sometimes a sliding scale. Political speech versus commercial speech, for sure. Those tend to be regulated differently. Commercial speech typically is regulated at intermediate scrutiny, not strict scrutiny. So the government can, for example, do a lot more things. For example, insisting that you say certain things, which is why every drug ad has that long list of disclaimers, because they have to say it, because it's commercial speech. So that's how that goes. Pornography versus obscenity. Obscenity is a legal definition under the Miller test. Essentially means that it has no purpose that is legitimate and appeals to the prurient interest. So it is, you know, just purely sexual without any redeeming value. It's a little bit more complicated than that, but that's a shorthand definition. Viewpoint versus content. There is potentially a difference between the two. In the flag burning case, Texas versus Johnson. In Texas versus Johnson, the Supreme Court implied that viewpoint discrimination might be per se unconstitutional, whereas content-based regulation might only be strict scrutiny. Although lower courts in applying it haven't really applied it that way. But there is a colorable argument to say that viewpoint is even more protected than content, as in the government can never do it, ever. So there's an argument. Tradition versus designated versus limited public forum. That is well established in the First Amendment analysis completely. So the park is the quintessential traditional public forum, or the sidewalk is the traditional quintessential public forum. So all else being equal, you can take out your soapbox and say whatever you like. You know, but other forums are not necessarily open. For example, the DMV is a DMV. You can't go in there and, you know, have a picnic, you know, because it would be disruptive to the governmental operation. So yes, these are well established, because the First Amendment only applies, you know, if it's the government getting involved. And so we have to decide like what kind of places have what kind of rules. And so that's sort of what that is, but that's been established for, you know, a long, long time. So no problem with that. Thought versus speech versus conduct. Well, fortunately, you can't regulate thought, thank God. Conduct can be extremely regulated, and speech is the First Amendment. Separating speech sometimes from conduct can get tricky, but when you can separate them, conduct can basically be regulated however you want, to the extent you're not involving speech. Many free speech categories were subject to reasonable time, place, and manner restrictions. I don't know about many, but yeah, I mean, that's generally correct. Time, place, manner restrictions are generally lawful because it doesn't go to what you're saying. It just goes to the exact manner by which you're saying. For example, not allowed to use sound amplifying equipment, not allowed to be in this space, you know, past a certain hour, etc. Beginning in the late 20th century, free speech jurisprudence absorbed expressive individualism as the sine qua non, which is a fancy way of saying that which without, in other words, essential, the essential part of the First Amendment analysis. Okay? But newer cases retained older rules relevant to protest, forum, time, place, and manner, plus important outer limit on expressive conduct, especially sexualized expressive conduct. When children are involved, the calculation changes. That much is true. Here, the plaintiffs expressly contemplate and even advertise the involvement of children, which I don't think was correct. I don't think that was what they were doing. So I don't think that is correct. But yes, sexualized conduct has long been regulated for time, place, manner restrictions, for example. Yeah. But yeah, that's true enough as far as it goes, but you're misapplying this. Plaintiffs neither plead a clearly established right to hold a sexualized drag show on campus, which is being way over specific about what we're talking about, nor that the president of the university's response was objectively unreasonable. It was, and even he admitted to as much. He said it was unlawful. And although plaintiffs recite and repeat expressive conduct boilerplate from landmark cases, they elide the constitutional and statutory taxonomies necessary to decide a free speech campus case, at least in this motion to dismiss phase. Specifically, plaintiffs failed to plead adequate facts and arguments in 4 categories of First Amendment law necessary to overcoming qualified immunity protection. So we're going to rest this in qualified immunity? I don't buy that either, because the free speech cases with universities have been established at the U.S. Supreme Court. So I don't think we can root this in qualified immunity as much as you want to try. And also, by the way, qualified immunity doesn't have anything to do with going forward. Qualified immunity has to deal with going in the past conduct. But these people are seeking injunctions in the future and declaratory relief in the future. Qualified immunity is irrelevant. So the court's just screwing up the analysis on many levels. First, if the fundraiser features cross-dressing like other theatrical performances, but not an overtly political message, does it convey intentional and overwhelming apparent message required in the campus protest cases to apply to school settings? I suppose not, but I'm not really sure what that matters. Notably, landmark cases cited by plaintiff include a warning to this court. We cannot accept the view that apparently limitless variety of conduct can be labeled as speech whenever the person engaging in the conduct intends thereby to express an idea. Fair enough, conduct can be regulated. As pled, plaintiff's proposed event does not obviously convey a discernible protectable message. Bullshit. It may not be a political message, but it's a theatrical message. It's a theatrical performance. So maybe this isn't worthy of, the utmost top tier free speech scrutiny, but it's still worthy of First Amendment protection. So that's dumb. Second, using textbook as an adjective is no substitute for the form analysis required in a free speech campus case. The analysis that determines whether the alleged discrimination is content or viewpoint specific. I'm not sure it matters, and to the extent it matters, viewpoint would be more protected. Similarly, the Texas Educational Code 51.9315 protects traditional public forums in common outdoor areas that is not necessarily determinative of the question here. Is it relevant WT facility a traditional public forum, designated public forum, limited public forum, or non-public forum for the First Amendment analysis? Well, it does matter. Thus, the forum analysis falls flat. Now, that's some bullshit. So the relevant way to determine this, by the way, would be what are the rules for other organizations that want to hold events that can be said to be comparable? Perhaps this particular building is not made available to students for their own purposes. Could be. There's probably buildings on campus like that. So the relevant analysis, it's not a traditional public forum. I will agree with you. It's not the traditional public forums are all outside. It's the park, it's the sidewalk. So this is inside. So I don't think there's such a thing as an inside traditional public forum. So the question would be, okay, is it a designated public forum? And the answer to figure that out is, well, how does the university treat this space with respect to other groups? Are other groups allowed to come here and have meetings and such? And if so, then they have to make it available to everybody. That would be the thing. So the form analysis, they say it's irrelevant. It's like, no, that's wrong, court. You're just full of shit. Third, plaintiffs acknowledge and attach WT policy stating expressive activity is subject to reasonable time, place, and manner restrictions consistent with the First Amendment, but consign their issue and analysis to the footnote. But that isn't what they're trying to do. The university isn't trying to restrict it as to time, place, and manner. They're trying to prohibit it outright, which is not the same thing. But this court cannot so easily ignore binding Supreme Court precedent holding sexualized conduct is more regulatable under various First Amendment doctrines, especially when children are the audience. But that isn't the right thing. And they said that the children would be there in the presence of the adults and a lot of other things. So that analysis doesn't make any sense. Thus, and also, by the way, this citation to FCC versus Pacifica Fund is a pretty bullshit citation. Finding the FCC may regulate monologue referencing sexual activities because children are the audience. Yes, the FCC has the ability to regulate, but only as it relates to broadcast television. The FCC does not have this power with respect to cable television or the internet or whatever. So this is a bullshit citation because it has nothing to do with this current situation. So that is just a bullshit citation. Thus, even if plaintiff's proposed event is lawful, WT could arguably relate the time, place, and manner of the show to protect children. But that isn't what they're trying to do. They're trying to ban it outright. So what are you talking about? Fourth, President Wendler's letter expressly or impliedly invoked countervailing federal, state, and WT policies relevant to harassment of other protected classes, specifically women. Okay, no. There are of course regulations as it relates to the workplace. There are regulations as it relates to campus even, but none of those things apply here. None of those things apply here. This is not being shoved in anyone's face. This has nothing to do with creating a hostile environment. You know, you can just not go to the drag show. That would be fine. You know, it has nothing to do with anything. So this is some pretty shit analysis. Yet plaintiffs never explain how or if defendants must reconcile these competing, conflicting legal obligations. There are none that are applicable to this situation. At this motion to dismiss phase, plaintiffs did not address or analyze President Wendler's arguably reasonable efforts. No, it's not. He's trying to ban it outright. This is not regulation. This is not an attempt to regulate. This is an attempt to prohibit. This is bullshit. If the president had said, okay, no minors allowed at all, that would arguably be a motion. That would be arguably a regulation. Or if they had said, you know what, you have to have it in this building, not this building, then, you know, maybe that's an ability to regulate. As long as, you know, it's not like shoving them in there for, you know, their viewpoint, but, you know, there are things you could do. Or, you know, this event can only be held at these hours. You know, those would be things to regulate. This is not an attempt to regulate. This is an attempt to ban. And that's not the same thing. And I'm mad. I'm mad. Under the Federal Rule of Civil Procedure 12b-6, the court evaluates the pleadings by accepting all well-pled facts as true, viewing them in the light most favorable to the plaintiff. To survive a motion to dismiss, a complaint must allege enough facts to state a claim to relief that is plausible on its face. A case is properly dismissed for lack of subject matter jurisdiction under Rule 12b-1 when the court lacks the statutory or constitutional power to adjudicate the case, and a defendant's entitlement to qualified immunity should be determined at the earliest possible stage of litigation. I don't know how qualified immunity is relevant to this. To be entitled to a preliminary injunction, an applicant must show a substantial likelihood of success on the merits, which they have, a substantial threat of irreparable harm if the injunction is not granted, which they have, the threatened injury outweighs the threatened public harm, which they have, and the granted interest will not disturb the public interest, which they have, so they should win. A plaintiff bears the burden of all four factors, and failure of any one of them can warrant denial. Qualified immunity protects government officials acting within their authority from individual liability when their actions could reasonably have been believed to be legal. And when there are no allegations of malice, there exists a presumption in favor of qualified immunity for officials in general and for education in particular. Once again, my disdain for qualified immunity is real, but I'm not quite sure how qualified immunity is relevant to this particular case. This is especially true where the area of law is abstruse and complicated as the First Amendment jurisprudence. Indeed, because the nearly universal prohibition against viewpoint discrimination does not inform an official as to what precisely constitutes viewpoint discrimination, you have got to be shitting me. You have got to be shitting me. Really? Really? Sweeping statements about First Amendment are not subject to deprive teacher of qualified immunity. Thus, educators are rarely denied immunity from liability. You have got to be out of your mind. You think that viewpoint is so vague that they don't know what we're talking about. You've got to be absolutely out of your mind. Viewpoint is just literally what position do you take on an issue, as opposed to subject matter. Subject matter is, I don't want you to talk about issue X. Viewpoint is, I don't want you to express opinion Y about subject X. So we're going to allow you to discuss the subject, but you just can't express opinion Y. You're allowed to like it, but not hate it. Or you're allowed to hate it, but not like it. Okay, that's what viewpoint is. It's not complicated. It's simple. And there seems to be statements from the president that very clearly indicate that this is viewpoint. It's not hard. Also, it's an injunction going forward and declaratory relief. So I don't even know what we're talking about. To defeat the presumption in favor of qualified immunity, plaintiffs must show the official violated a statutory or constitutional right, and the right was clearly established at the time. However, judges are free to decide which prong to analyze first, which, okay, fair enough as far as that goes. Subsequently, or substantively, a clearly established right is one sufficiently clear that every reasonable official would have understood what he's doing violates that right, which the campus president does because he basically said as much in his written correspondence. And it's the plaintiff's burden to find a case in his favor that does not define the law at a high level of generality. That said, there is no requirement the case be directly on point for a right to be clearly established, but existing precedent must squarely govern the specific facts at issue to place the statutory or constitutional question beyond all debate, which this is. Lastly, even if governmental officials' conduct violates a clearly established right, the official is nevertheless entitled to qualified immunity if his conduct was objectively reasonable, which this is not. In other words, immunity protects all but the plainly incompetent or those who knowingly violate the law, which is exactly what happened here because we have the president saying exactly that. This is just bad analysis. This is just bad analysis. Here, there's no dispute that President Wendler's actions were within the scope of his discretionary authority. There's a lot of dispute. Thus, the plaintiffs must demonstrate the president violated their clearly established right to overcome the presumption in favor of qualified immunity. At this stage, it falls short. I'm still unclear about why qualified immunity applies in this context. We're not trying to sue for a past wrong at this point. We're trying to get an injunction or declaratory relief. Why is qualified immunity relevant? Plaintiff's best case is non-binding 40-year-old opinion concerning a male beauty pageant from the Western District of Oklahoma. But that case is distinguishable for at least three reasons. First, it's not a campus case and therefore cannot clearly establish the rights of students on campus beyond debate. The U.S. Supreme Court did that long ago, as far as I'm concerned. Second, the defendants in the case did not produce a shred of evidence that the pageant includes depictions of sexualized conduct to support their conclusion the event was obscene. Third, the event holding that the pageant constituted protected expression is questionable when applied to the facts of this case. Bullshit. The First Amendment protects an individual right to speak his mind regardless of whether the government considers the speech sensible and well-intended. It certainly does. Historically, First Amendment jurisprudence countenanced reasonable limits on freedom of speech as alleged expression moved from thought to speech to conduct. Today, First Amendment protection for the latter extends only to conduct that is inherently expressive. In deciding whether particular conduct possesses sufficient communicative elements to bring the First Amendment into play, the court must first ascertain whether an intent to convey a message was present and whether the likelihood was great the message would be understood by those who perceive it. Well, I mean, it's a drag show, so I think we're good on understanding what it is. Courts have considered the context in which it occurs and whether the expressive, overtly political nature of the conduct was both intentional and overwhelmingly apparent, which would only be relevant if political considerations were present, which I don't think they are, so I'm not sure why we're citing it. And while it's possible to find some kernel of expression in almost every activity a person undertakes, such kernel is not sufficient to bring the activity within the protection of the First Amendment. Accordingly, a party must advance more than a mere plausible contention that the conduct is expressive, citing cases dealing with the Klan, which tells you how far afield we are on this analysis. Though apparel and attire are certainly a way in which people express themselves, clothing as such is not, normally at any rate, constitutionally protected expression. That typically is true in most situations. But that isn't exactly the case here. Instead, courts have applied free speech protection to manners of dress only when and where the context establishes an unmistakable communication is being made. Thus, the Ninth Circuit rejected the argument that scantily clad baristas conveyed a free speech message of fearless body acceptance and freedom from judgment, because that's some bullshit in that particular case. And consequently, at this point in free speech jurisprudence, it's not clearly established that all drag shows are categorically expressive. Well, I'll agree with you there, I suppose. I suppose I'll agree with you that not all drag shows are categorically expressive. But that is being incredibly lazy. Because you're like, well, not all of them are, so this one isn't. And that's incredibly lazy. The liberal parts of the bench do the same thing with the Second Amendment, right? They'll say the Second Amendment isn't absolute, which is true enough as far as it goes. And then they'll be like, well, this regulation's okay because the Second Amendment isn't absolute. And I'm like, well, that's really dumb. That's really dumb. That's like saying, okay, the First Amendment isn't absolute, which it is, which it isn't. And therefore, this regulation dealing with speech is okay because it's not absolute. Well, no, it covers things. It covers things. So sure, there are some drag shows which are not protected, I'm sure. But that doesn't seem to be the situation here, and the court pretending it is very lazy and disingenuous. Furthermore, as plaintiffs admit, some drag shows are intentionally risque, some comedic, some outlandish, and some will not give a moment's pause to the Motion Pictures Association. Yes, that's true. It can come in a variety of flavors. That's fair enough. But what about this one? Accordingly, an objective viewer observing biological men performing while dressed in attire stereotypically addressed with women, without accompanying political speech or dialogue, would not necessarily discern an unmistakable or overwhelmingly apparent communication of LGBTQ rights. I guess, but that's really stupid. For example, persons viewing male football players posing in cheerleader skirts, or the drag scene from the 1943 film This Is the Army, are unlikely to discern a political message. And even if explanatory speech could aid plaintiffs, the context of the show does not help. That is because an observer may not discern the performance conduct communicates advocacy in favor of LGBTQ rights. This is just really, really lame. This is really lame analysis. Plaintiffs cite a different case to argue First Amendment affords protections whenever people get on stage performs, but that case's holding turned on core political speech, specifically the right to openly criticize the government during a dramatic performance. There, the preparation and repeated presentation by amateur actors of a short play designed to create in the audience an understanding of and opposition to our participation in the Vietnam War. Thus, core political speech was at issue, not mere expressive conduct and certainly not sexualized conduct. Similar facts have not been alleged in this case. I suppose that's true. That case is a bit inapplicable, but you are being very, very disingenuous in this whole analysis. Accordingly, or additionally, the Supreme Court's decision in a different case is unavailing. There, the court held unconstitutionally overbroad an ordinance banning all live entertainment, including non-obscene nude dancing, otherwise protected from the First Amendment. Unlike those cases, there are no overbreadth issues at this case, which I disagree with. There are overbreadth issues. Furthermore, plaintiffs miscite and misread a different case from the U.S. Supreme Court. Like other cases, this case concerned a controversial show on municipal property, not a university campus. It doesn't matter. It doesn't matter. They're both owned by the public. It doesn't matter. And the show was a rock musical rather than a drag show, or what the Supreme Court characterized as live drama. I'm not sure that matters either. Specifically, the performance entailed the acting out or singing out of the written word and mixed speech with live action or conduct. Lastly, the case law predates the Supreme Court's delineation of limited public fora as a distinct price of property, thus it cannot establish the right beyond debate. This is really, really dumb. Because men dressed in attire stereotypically associated with women is not overtly political, in a category of performative conduct that runs the gamut of transvestism, e.g., whatever in a different language, Sigma Chi fraternity's brothers in a distasteful ugly women contest, whatever priest worshipping Yalama, and Matt Damon depicting Yale University thespian in The Good Shepherd, it is not clearly established all drag shows are inherently expressive. What the hell are you talking about? What the hell are you talking about? But even if the First Amendment is implicated, which because it is, President Wendler knew of potential lewdness, which is protected under the policy of the university, which prohibits public disrupt behavior that is disruptive, lewd, or indecent. But did you ban it because it was lewd? Did you ban it specifically because it was lewd? Did you ask them what they were doing, and did you ban it specifically because it was lewd? If not, what are we talking about? And the First Amendment does not protect school officials from restricting vulgar and lewd conduct that would undermine the school's basic educational mission, particularly in settings where children are physically present. Yes, particularly in settings where children are present. The case law, when it comes to educational environments, is split between K through 12 on the one hand and universities on the other hand. The reason the case law is split is because K through 12 involves children and universities don't. So the case law is split. So, yes, if we were talking about this at a high school, we'd be having an entirely different discussion. But we're not at a high school. We're at a university. So there's that. Here, plaintiffs advised the president that the event would be open to children. Although plaintiffs attest the show was rated PG-13, a term undefined by plaintiffs, but presumably based on the familiar Motion Picture Association ratings, contemporaneous media accounts of similarly advertised events reflect a range of highly sexualized conduct. Well, if that was the concern of the president, if he was really concerned about that, he could have asked for more clarifying questions and said the university does not permit lewdness. So I need a little bit more about what you're doing, so that I can make sure that your performance isn't lewd. And then we could have a discussion about even whether that is lawful or not. But we didn't do anything like that, so I don't know why we're talking about it. Although the court infers in plaintiff's favor that the show would not have been lewd, which of course you're required to do, plaintiffs do not allege the president was aware of their efforts to purge lewdness. Well, it doesn't matter, because one of the things they're seeking is declaratory relief going forward, and injunctive relief going forward. So his awareness might go to qualified immunity in the past. Can we sue him for the past? Perhaps we can't. But as to an injunction, how's qualified immunity relevant to this? How's declaratory relief relevant to this? I don't know. Additionally, plaintiffs selected an MC whose past performances were arguably inappropriate for children of any age. Miss Mika performance involves simulated stripping and accepting money from audience members as if he were a stripper, simulated masturbation, bouncing feminine breasts, possibly prosthetic, possibly not, and frequent presentation of his barely covered crotch. Well, again, if that was your specific concern, you could have laid out that specific concern and we'd be having a different discussion. That's the thing. If the text wasn't on screen as I was reading that, I apologize. I forgot to switch back. But yes, if this was your specific concern, then you could have laid out those specific concerns and we'd be having a different discussion. We'd still have to decide whether or not it was lawful or not for the university president to do that, but we'd be having a much different discussion rather than him just banning it outright. So this analysis is inappropriate here because this doesn't reflect what the university did. So it doesn't matter. So I don't know why we're talking about it. Plaintiffs cite a different case, which involves a campus newspaper and political cartoon depicting policemen raping the Statue of Liberty and the Goddess of Justice. This is probably the best case on point when it relates to university free speech. There, the Supreme Court held that mere dissemination of idea, no matter how offensive in good taste, on a state university campus may not be shut off alone in the name of decency. But Papish cannot clearly establish plaintiffs' asserted right because the government generally has a freer hand in restricting expressive conduct than is restricting the written or spoken word. That is just, no. And even if that's true, again, this is just an outright ban. Right? This is just an outright ban. If it had been the university like, look, we're not going to allow lewdness and we're regulating your conduct. So we're not going to permit any lewdness. So tell us exactly what's going to happen. Or even they insist on someone being there. And like, if you break our rules, we're going to shut it down. You know, because you broke our rules as it relates to conduct. If that's what they had done, we'd be having an entirely separate discussion. But this is not right. This is not right in this analysis. It's just a flat out ban. And that you can't do that. That a school newspaper cannot censor political cartoons, which is not correct, by the way. That is not what this case said. It didn't say that the school newspaper couldn't do it. It said that the school couldn't do it. That was the thing. The school newspaper could have censored it. They didn't want to. You idiot. That a school newspaper cannot censor political cartoons, which isn't what the case said, did not clearly establish a right to parade Miss Miska barely covered crotch before an audience that includes children arrayed in a limited public forum. Again, if this had been the concern, if the president had said, we don't like your MC in the past has gone too far. We don't think that that's a good MC. Could you pick somebody else? If that had been the concern, we'd be having a completely different discussion. But we're not, so this is completely dumb. And it was offensive conduct that caused the email to restrict, not offensive ideas or political messages. Bullshit. In fact, the president expressly supported the noble cause of supporting LGBTQ self-deletion prevention. Well, maybe, but that's neither here nor there. Next, plaintiffs cite Iota Xi, chapter of Sigma Chi fraternity, versus George Mason. But this too did not concern a drag show. Sigma Chi involved a male fraternity ugly woman contest, an exercise of teenage campus excess with an obvious sophomoric nature. In the university's view, the problem was not the conduct itself. Rather, the message conveyed by the contest ran counter to the views the university promoted: racial integration and gender neutrality. Well, if that's the issue, get bent. Get bent. If you don't like the message, shut the hell up. Accordingly, the court applied Johnson and found the message likely to be understood by the audience. The racial and sexual themes should be treated lightly. Additionally, the school's sanctions that included suspension from all activities for the rest of the 1991 spring semester, a 2-year prohibition on all social activities, and requirements Sigma Chi to plan and implement an educational program addressing cultural differences, diversity, and the concerns of women. Thus, the question was not whether Sigma Chi had an unqualified constitutional right to dress members in outlandish and stereotypical female attire. The question is whether the school could punish the fraternity because its Boris message had interfered with the mission. But here they haven't been sanctioned by the president. Well, they forbid the speech, which is just as good. And it's the conduct contained in the message that identifies, not the message, which if you believe that, which I'm not even necessarily inclined to believe that, by the way. Plaintiffs next turn to a different Fourth Circuit case. There, the issue is where the Baltimore Police Department could condition the continued employment of one of its police officers upon cessation of off-duty public entertainment performances in blackface that members of Baltimore's black community found offensive. Yeah, okay, so when we're dealing with police officers and other governmental employees, the analysis can get complicated real fast. And we have to turn about all kinds of different doctrines at that point. Because at that point, we have to try to separate the governmental employee from the person. The person is allowed to do things. The governmental employee is not. The governmental employee has no freedom of speech. The person does. And here, the problem probably is that the tie is too strong, that it would undermine the government's mission. So yeah, you can probably restrict this because he's a governmental employee. And that comes with things that, because part of you is the government imprimatur, the government gets some control over when and how you can say things to some degree. It's not an absolute thing, but to the degree it undermines the work, they have the ability to regulate it, kind of like any employer, kind of, sort of, mostly. So yeah. A New York judge was fired due to his OnlyFans gig. Yeah. And I can't speak again to the legality of that particular situation, but there's a potential problem, right? Separating the person from the office might be too tricky. So, yeah, so that's the kind of analysis there. All right. Hence, that case involved neither direct shoes nor campuses, but instead the heavy regulated in public employment sector. And indeed, the case's only real similarity to this case is that it broadly concerned a form of entertainment some members of the community found offensive. But it cannot clearly establish plaintiffs' asserted right when it would otherwise involve different facts and a different body of First Amendment law. Finally, plaintiffs cite Supreme Court decision in Widmore. This too misses the mark. Widmore only addressed content-based exclusions of religious speech in an open forum on campus. It does not clearly establish a right to conduct a drag show on campus in a yet-to-be-determined forum, although it wasn't yet to be determined because they had a space in mind. Though First Amendment practitioners rarely miss an opportunity to drop a Widmore quote out of context. Well, that's disingenuous too. Plaintiffs thus failed to clearly establish a First Amendment right to conduct a PG-13 drag show with performances like Miss Miska at a designated or limited public forum on a university campus in front of children, which is a very disingenuous way of framing whatever this case is about. None of these cases involve a drag show of the type that had become increasingly controversial, and except for Conrad, none involved potentially lewd conduct. Nor are they especially helpful in addressing the limits of reasonable time, place, and manner restrictions on indecent conduct, or ways school officials might justify restrictions on protected forms of expression. Critically, even if lower cases were directly on point, it would be insufficient to create a robust consensus that would clearly establish an asserted constitutional right beyond debate. Plaintiffs lament that President Wendler's email states he will not allow drag shows, even where the law of the land appears to require it. But for reasons explained, the law is not clearly established, if it's even the law at all. Wow, that's one way to flip that on its head. That's one way to flip it on its head. I won't do it even if the law requires it, but it's not clear what the law requires. Wow, that is amazing. That is truly amazing from this district judge. Wow, I can't believe he wrote that. To the extent President Wendler's statement conveys a belief that there is a clearly established right and not an expression of confusion typical of many Americans on what the Constitution requires, his statement is incorrect. His statement is incorrect and therefore legally irrelevant. Wow. Wow, that is amazing. That is amazing. We have the statement from the president who says, I won't allow it even if it's legal. And the judge says, well, you're wrong about what the law requires, so it doesn't matter. Holy God, that's just unbelievable. Chef's kiss. Stupid. At this point, I have no problem saying that this opinion is even stupider than the New York Times thing we started with. Because this is just horrible, horrible legal analysis. Absolutely atrocious legal analysis. Absolutely atrocious. You know, just dumb. Just incredibly dumb. For the foregoing reasons, President Wendler did not violate the plaintiff's clearly established right and therefore is entitled to qualified immunity, which it doesn't matter because we were looking for forward-looking relief. So I don't know why we're talking about qualified immunity. Accordingly, plaintiff's damages claim against the president in his individual capacity must be dismissed. Well, to the extent we were looking for damages, I think you're right. But to the extent we're talking about an injunction, I think you're very, very wrong. Yeah, then they say sovereign immunity. So now we'll talk about sovereign immunity. That'll be fun. Which we do have to talk about because it's a state university. And we do have to talk about sovereign immunity. So let's talk about that for a while. Okay. Qualified immunity is immunity from a suit rather than a mere defense to liability. Still, the defense is not available where injunctive relief is sought in addition to damages. However, the 11th Amendment generally bars federal courts from telling state officials how to conform their conduct to state law, for one can hardly imagine a greater intrusion on state sovereignty. Yes, the federal courts do not rule on state law. That's true. One exception to sovereign immunity is where a lawsuit against a state official in its capacity seeks prospective relief. Prospective relief. For that to apply, 3 criteria must be satisfied. A plaintiff must name individual state officers as defendants in their official capacity. A plaintiff must allege ongoing violation of federal law, and the relief must be properly characterized as prospective. A complaint must allege the defendant is violating federal law, not simply the defendant has done so. Well, they are. They are, because they've announced in the future. They are. This requirement is similar to, but not identical to, standard Article 3 minimum for standing to request an injunction, which requires ongoing harm or threat of imminent harm. I think you're there. I think you're there because the university president says, I'm not going to allow that. I think that's future harm. It's specific enough. It's tailored. It's directed to you. It meets all the criteria for me. Accordingly, where there's no ongoing or independent violation of federal law, a federal court may not issue declaratory or notice relief, even though the relief would be prospective and not require payment from the state. Lastly, in determining whether ex parte Young applies, a court need only conduct a straightforward inquiry into whether the complaint alleges an ongoing violation of federal law and seeks properly characterized as prospective. The court need not accept allegations of ongoing harm at face value. The allegations must be plausible. They're plausible. Here, a plausible reading of the facts might suggest plaintiff's only evidence of harm is a single letter distributed via email. No, it seems to speak to the future too. And because plaintiff's other requests have been approved since the denial, including drag show practice, there are no arguably ongoing consequences. Well, if he hasn't, in fact, going forward interfered, then maybe you do have a point. However, the court at this stage must view the facts in the light most favorable to the plaintiff. That too. And the president's email unequivocally declares the university will not host a drag show because a harmless drag show is not possible. That looks specific enough. That looks specific enough for declaratory relief to me. Thus, plaintiff's allegations are sufficient to satisfy the ongoing violation prong. I think so too. Therefore, the claims are not barred by sovereign immunity. Accordingly, the court denies the motion in part and turns to defendant motion. Okay. We lack standing against the board. Okay. The judicial power of federal courts is limited to certain cases in controversy. This case or controversy requirement requires a plaintiff to establish he has standing to sue. To have standing, the party invoking federal jurisdiction must show that he suffered an injury, in fact, concrete, particularized and actual or eminent, which we're there. The injury was caused by the defendant, we're there, and the injury would be addressed, we're there. Huzzah, we've met all those things. We have standing. Courts should adjust whether the alleged injury to the plaintiff has a close relationship to harm traditionally recognized as providing a basis for a lawsuit. This is a First Amendment thing. I think we're there. And because vicarious liability is inapplicable to 1983, which is fair enough as far as it goes, the plaintiff must plead that each government official defendant through their own actions to violate the Constitution. Okay. Aside from President Wendler, plaintiffs have also sued the Vice President of Student Affairs, Christopher Thomas, Chancellor John Sharp, and each member of the Board of Regents. Here, the parties quarrel over whether WT defendants had any part in President Wendler's decision, have any authority, individually or collectively, to overrule that decision, are eminently likely to prevent a second drag show. The court finds the plaintiffs have standing against Dr. Thompson and Chancellor Sharp, but not against the board. To begin, plaintiffs allege Dr. Thomas enforced President Wendler's directive and is likely to enforce future directives. Likewise, President Wendler is subject to and under the general authority of Chancellor Sharp. Chancellor Sharp is responsible for supervising the implementation of basic policy, making recommendation for policy to the board, and has been delegated authority to do with all things necessary to fulfill the responsibility. Chancellor Sharp has a history of involving himself in university free speech matters, but as plaintiffs note, he did not overrule or even denounce the letter. Thus, plaintiffs persuasively plead an apparent disconnect in university policy. Under Chancellor Sharp's leadership, the Texas A&M University system is a national leader in LGBT advocacy, with the College Station flagship hosting Lavendier graduation, coming out monologues, and Draggyland events at its LGBTQ Pride Center. Yet, affiliate WT charts a different course, at least in this case. At earlier stages of litigation, the manner and degree of evidence required to show standing is less than other stages. It does not appear certain at this motion to dismiss phase that plaintiffs cannot prove any set of facts in support of their claim that would entitle them to relief. In other words, it's plausible that Chancellor Sharp and Dr. Thomas have some connection with President Wendler's edict. While the court understands Chancellor Sharp's contention, he did not make the decision to cancel the previously selected drag show. He does hold authority to permit or deny future ones. And because neither side has adequately shown that Chancellor Sharp and Dr. Thomas have no role in this case, the court declines to exclude them at this point. The court there denies the motion in part. The analysis changes for the board defendants. Plaintiffs rely exclusively on the fact that the government of the university is vested in the board, which has the power to make bylaws, rules, and regulation it deems necessary and proper for the government of the university system and its institutions, agencies, and services. But, absent any allegation tying the board to a specific decision issue, it cannot plausibly be inferred the board played any direction. This is pretty consistent, this part, with analysis. As far as it goes, this is pretty consistent, right? You can't go after the manager unless the manager has some sort of specific thing. You need to prove it individually. So this part is consistent with the law, for what it's worth. To be entitled to a preliminary injunction, plaintiffs must show a substantial likelihood of success on the merits, which is one of the most significant factors. And while plaintiff must also demonstrate irreparable harm, which is perhaps the most important prerequisite for a preliminary injunction, which is very much assumed, by the way, when it comes to freedom of speech, that's irreparable harm. Here, plaintiffs have not demonstrated they're substantially likely to succeed for the same reason the president is entitled to qualified immunity. Bullshit. Even if denial of the drag show does implicate the First Amendment, which it does, plaintiffs have not demonstrated that the university's policy on drag shows is incapable of surviving intermediate or strict scrutiny. Wow. Wow. Also, why is intermediate or strict scrutiny the right standard? Why is it the correct standard? As opposed, you didn't do that. Why is it not strict scrutiny? You didn't say. And because, they say intermediate or strict scrutiny. You don't think the policy on drag shows is you think it's possible the policy on drag shows might survive strict scrutiny? You're out of your mind. You're out of your goddamn mind. And because plaintiff's irreparable harm analysis is predicated on clearly established First Amendment violation, which this clearly is, their argument for that factor must fail as well. In any case, plaintiff's second show is not scheduled until March 2024. It is therefore doubtful plaintiffs will suffer irreparable harm in the coming months while this issue is litigated. That is such a disingenuous way of looking at this. That's such a disingenuous way of looking at it. At this stage of litigation, plaintiffs cannot prevail by invoking the word expression, as if the free speech clause obligated all logical distinctions, separating thought, speech, and conduct, time, place, and manner, and children from sexualized conduct. The children are not relevant to this analysis, and I wish you'd stop bringing them up. It does not. Of course, plaintiff may still prevail on the request for declaratory relief, but it's a matter for another day. And because these factors are not satisfied, the court not reach the other factors for injunctive relief. For these reasons, the court grants the motion and blah, 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 some stupid. By Judge Matthew, whatever, who is an idiot. Well, that was exciting and a whole pile of stupid. That was exciting and an incredible pile of stupid. So, yeah, I mean, I'm annoyed. I think you're annoyed. We're all annoyed. It's annoying. So, yeah. So, I think that will conclude us for today. We've had a long stream. We've had a lot of streaming. I hope you've learned something. I've learned something. And we've all had an interesting discussion about legal theory. So that was good stuff. That was good stuff. So I'm glad you were able to join us. And I think I'm going to go ahead and sign off now. I've been Uncivil Law, and I hope all is well. Cheers, my friends, and for now, goodbye.